have a contract, to have a contract, the first thing you have to know is what are the essential elements that makes a contract valid. You must have offer, an acceptance, consideration, intention to create legal relations, and capacity. So first, that means that someone must make an offer. Then it has to be accepted. And in order for there to be an agreement, consideration must be made, which means like if you're buying a piece of property or if the contractor is building, I don't know, adding on to your house or whatever he's building, there is a deposit to be made without consideration. Then his intention to create legal relations. And that means whether or not both parties have the capacity. No, intention to create legal relations means that the minds of both parties have to be aligned, which means that yes, they want to enter into a contract. And the last one, which is capacity, it means that both parties must have the capacity to enter. So if they're individuals, they have to be 18 years or older. If it's a company, the company has to be in good standing. So those are the elements of a valid contract. Whenever you enter into a contract, you have to read those terms and conditions, because those terms and conditions tells you what if something happens, what is your recourse? And if you don't see certain provisions in the contract, then you need to ask the contractor, if that's the person who drew up the agreement, I don't see provision in this contract for in the event that this happens. So when you have a valid contract, after those 5 essential elements, you have to then look at formation, how and when the contract is created. Then you have to see whether or not the contract is valid in terms of enforceability, which means that if something happens, can you enforce the provisions within the contract? Then set out in the contract should be those terms and conditions. The vendor's responsibility, the purchaser's responsibility, or the mortgager's responsibility, and the contractor's responsibilities, their duties, the obligations. And then you look at the legal liabilities. What happens in the event something occurs that the contractor cannot finish or the mortgagor cannot pay? Like what happens if the mortgagor passes away in the middle of construction? So those kind of things you need to look at when you enter into a contract for certain matters. Then you must have a provision in for a discharge. That is how the contract is to be terminated. And of course, you always think about limitation, how long you want the contract for, if there is an action, when to bring that action. And then you have to be mindful also of the remedies that are available for a breach of contract. And always remember, the only person who can bring an action for a matter is the person who is a part of the contract. And that's called privity of contract. So all in all, when you enter into a contract between yourself and the contractor or yourself and the realtor, you have to make sure that the provisions that you're looking for are within that contract. Even though they may say the contract is standard, if there are certain provisions that you feel should be in there for your own comfort, you should ask for it. So how do you discharge a contract? That can be done in 4 ways. You and the contractor could agree that you want to bring this contract to an end. And you could pay whatever it is that you owe. Or the contract can come to an end by both parties fulfilling their end of the obligation. So there's no dispute between the contractor and the mortgagor. Now, the contract can also come to an end if there is a breach. And then that's when the innocent person has the right to sue. And by suing, they bring the contract to an end. And then the last way in which a contract can be discharged is if there is frustration. And frustration means that the contractor, it could be the contractor, he is unable to complete the job. Or you as the mortgagor can't complete your end of it because maybe you passed away or someone in your family passed away, your obligations have changed. So those are things that frustrate the contract. Now, there are remedies under common law and equity. Under common law, of course, you could sue for damages. Sometimes within the contract itself, it has an agreed sum, where the persons will say, in the event there is a breach of contract, there is a penalty of 15% or 20% of the sum of the whole contract. Or you could have quantum merit, which is just as much as it is worth. Now, sometimes the aggrieved person may decide that they want a remedy from the court, an equitable remedy, and that's if damages are not adequate enough in order to satisfy them for the damages that are being caused. So you can go to the court and you can ask for specific performance, which means there's a court order that says you have to live up to your end of the bargain. Or you could have an injunction which says to stop. Or you could have a rescission, and that's what the court does, is it terminates the contract. And then it puts the parties back into the position that they would have been in if they had never entered into the contract. And then, of course, rectification. That's only where the court wants to correct the mistakes in a written document. Any questions or comments? No?
No, ma'am.
No one want to tell their horror story with dealing with a contractor?
It's actually, I found I have certain contractors on my own personal blacklist in dealing with mortgages. No, seriously, and I'm so serious with that. I tell my customers when they come to me, the first thing I want to see is the contractor that they say they're going to deal with. And based on past experience with how they've managed their their projects, I tell them that I'm not willing to deal with them. If they insist, then they have to go to another financial institution or another lender even. But because it's I tell them, I said, everybody is good friends. Everybody's in good standings. Everybody doing well while things, in the beginning. But I've seen too many times where the project goes sideways. The contractors mismanage the funds. We have a lot of contractors who have basic knowledge of the, plumbing, carpentry, whatever it is, their skills, but they cannot manage finances. So when they have this whole heap of money going through their hands, they mismanage it, and the projects are never completed, and they end up in court. And no matter how you try to caution these customers up front, and you try to give them the best advice, after the contractor and promise them this, sometimes they cut their little deals on the side, and they think they get a little extra money out of it. They still blame the bank at the end of the day when things don't go right.
Yes. And it comes to something that we see in every aspect in the Bahamas. everybody always want to get something out of the deal.
And
Yeah.
Ms. Archer, I want to concur too as well, in that the customer really think they be winning. And in the end result, they want the bank to be the mediator between them and the contractor, when you would have guided them and say, no, 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 this is supposed to be for this purpose. This is supposed to be for this purpose. And then the contractor promised them a whole heap of stuff. And then at the end of the day, it isn't completed the way they had promised them to have it completed. Then you're going to find out all the details behind it.
Yes, yeah,
The contractor is going to defend himself and say, I did much more work than it's supposed to have been. I didn't charge you for this and I didn't do that. I had a situation where the house appeared to, and then another thing, we hold what we call a retainer, making sure everything is completed before you release. But the contractor gonna talk you into releasing that retainer, and then you're gonna discover that there's a hole in the bottom of the floor that was never covered, just a tile was thrown across the hole.
yes, yes. Mhm. But the thing is, I believe that the legislation passed, the contractors legislation is supposed to address some of those things. Now I know it's being slow in moving, but you're supposed to register now as a contractor.
Yes, here in Grand Bahama, you have to register with the Port Authority. And one initiative I saw they launched that was really good was they have to take certain classes.
Yes,
So
that's yes, it's in the legislation,
mhm.
and that's what they're supposed to be doing here in Nassau also. You're supposed to be registered. We'll come to that under the contractors legislation. So if you look at realtors, real estate agent and brokers, they have on their website, they tell you that you can't just use that designation as a realtor. And you can see from a lot of cases that we have done, a lot of people have gone around selling property, even as individuals. We don't know if they purported to be realtors, but the point is that you actually have to pass exams and pay your annual fees in order to carry these titles. So that's another thing that people have to look at when they just want to, on an individual basis without going to a bank, decide to purchase a piece of property. You have to verify that these people are actually licensed to do this business. So Bria says that the National Association of Realtors has the sole right for you to use that name, realtor. Any member of an affiliate association such as Bria is entitled to join the National Association of Realtors. Only then will you have the right to use the word realtor. That's putting that little R behind your name. So unless it applies to you, you're breaking the law when you refer to yourself as a realtor. And when you use it in your promotional materials, or even if you use it on your website.
So now, Ms. Archer, what I do not get, I guess Bahamians always find a way, and I don't want to generalize, but we always find a way to work around things and always find a way to profit from it. Because I know some of the realtors who may have done the examination 100 years ago, get these other people selling properties under their name, under their company's name, and they went to the first class.
Yes, and that is illegal under the Bria rules. Because if you're a realtor and you have real estate agents under you, those real estate agents have to sit exams and they have to pass it. And then what happens is when those real estate agents sell, they get a percentage. So
Right.
the more agents out there selling, that's the more money they make. They don't really have to go out in the streets.
Right.
They sit home and they collect their money.
That's it. You don't want to know what they're giving the agent who they're working hard. Just because they can use your name.
Yeah, but that's how that works. So you have the realtor and he has his agents under him. That's how it's structured. And they make their money from the agents that go out. And the agents have to hustle in order to make whatever little properties that they sell to get their commission. And that's why you see there's so many of them out there. So the real estate agent often acts on a contractual basis with the vendors or the purchasers in the real estate transaction, and they're paid commission, and that's normally done on the gross sale or the purchase price. And of course, the deposit is required between the vendor and the purchaser. So the real estate broker is permitted to charge and collect a commission on the total cost to purchase the property at a private sale or an auction or foreclosed property sale. So you know there's always that competition between the leading real estate companies and the smaller ones. The leading ones has the big properties, the keys, the hotel chain properties. And then the smaller real estate agents have the little small 100 by 50 and 100 by 75, or maybe a duplex or a triplex. So all of those little agents you see underneath a realtor, they're trying to get to that point where they'll be able to make more commission. So real estate agents and brokers are registered under the Real Estate Brokers and Salesmen Act, 1995. And in that act, it outlines the registration process for brokers and salesmen, the regulation of that practice, professional misconduct, disciplinary action, and the requirements in handling real estate transactions. So I listed here the cost involved in buying or selling property, and you could read that. Now, the real estate agent has fees. And I put here the BREA fees. Developed property is 6% of the sales price. If it's a farm, grove, undeveloped property is 10%. Business opportunities is 10% of sales price. Car parks is 10%. Leasehold, for the selling of leasehold, the charge will be 6% of any consideration. And deferred sales collection is 2.5% of the amount collected. So it is a lucrative business. As you see every day, you read.
Where are you reading this from?
What page that on? 101?
101, 101,
Okay.
101.
page
Alright.
101.
Thank you.
So if we digress for 1 minute with the property on what island is that? RCI. The one that's in the newspaper now that everyone is talking about, that a lot of people are against. Where Royal Caribbean wants to build their, what is that, amusement? The Royal Caribbean Cruises.
Isn't that in Nassau? Where the lighthouse and Paradise Island?
Yes, Paradise Island, not Nassau, it's on PI.
Okay.
People are against it. Because what the government has done is sold them crown land. So the argument was the opposition were against it. Now they're in power, they are for it, but they said that they've changed the deal. Glenys Hannon Martin said that she's not for it. The Prime Minister said once she sees the final product, she will agree. So they're doing a project for $100 million. And it's a beach club project on Paradise Island.
I have a question. Is it because they are the government, they can go ahead and sell Crown land? Because everything I wrote, I read said you're not supposed to sell Crown land.
See, well, they say here that the prime minister, when he was in opposition, he was strongly against granting any Crown land lease to Royal Caribbean. And his argument was that we should lease it to a Bahamian company for development. But when they gave them approval, a couple weeks ago, they gave them approval, and that approval included 4 acres of Crown land. And I think the argument was that the amount that they were, I don't know whether they sold it or or leasing it to them, was less than what the former government was arranging with them. So what they plan to do is this: they intend to convert the 4 acres of Crown land into an equity stake in the project. And then that equity stake, they say, will go in our sovereign wealth fund.
Such a fund exists for the Bahamian people?
Well, they spoke about it when they were contemplating drilling for oil.
And let Lincoln be and tell them how they done sell off everything else and we ain't get nothing for it.
Let me see. I see where there is talk of it in October last year. Again, that had to do with the oil. Now, whether that as a piece of legislation has been passed, I don't remember seeing it. Because it seems to be a futuristic document. Because it says the Sovereign Wealth Fund will place the Bahamas among the top tier by helping to mobilize private capital and direct investments towards critical infrastructure projects. But I don't, the legislation we're tabling today is the National Investment Fund. No, I don't know. I don't know what happened to the National Wealth Fund. I'll have to find out from finance. I'll see if that was actually tabled.
Okay, thanks.
Don't be too hopeful now.
Well, we hope.
So I don't remember seeing that on the list of legislation. I don't remember seeing that. I mean, now I don't want to do the oil anymore.
Well, if he's going to propose the Paradise Island gate with Royal Caribbean, then maybe he would put something in play.
Okay, so let me see. In December, they debated the National Investment Fund bill that is going to replace the Sovereign Wealth Fund. They renamed it. So I need to find out if that was actually passed.
Oh, okay.
Called the National Investment Funds Bill 2022.
And that took the place of the sovereign fund.
The Sovereign Fund, because we never got to use the Sovereign Wealth Fund because we never pumped for oil.
Okay.
Remember, I think this is something what they were arguing about with the Aragonite as to why we're not getting anything from our natural sources.
I was
And we're-
just gonna say, but I don't think the Sovereign Wealth Fund was only linked to oil. There was also a linked to Aragonite, and they were saying salt,
You mean Morton salt?
Morton salt. they were saying we should have been getting some funds in the Sovereign Wealth Fund from our salt and from the aragonite, and then the drilling of the oil.
But they're not drilling for no oil, I'll tell you
I
that.
know they're not doing that anymore.
Mm-mm.
And he also bring
Mhm.
up the conch shell.
I guess they,
This Lincoln bean I'm referring to.
What else he brought up?
The conch shells.
Oh, you mean the ones that,
anything that's supposed to be our natural resources is supposed to be linked to that Sovereign Wealth Fund. That was my understanding.
Right.
Mm. But the Chinese is shipping out the shells.
Yes, I'm making millions.
Mm-hmm. Someone getting paid.
You best be sure. Ain't us, but somebody getting it.
Yeah.
Ain't that something?
That's
Wow.
That's how
That's
things
how we
work.
live. Uh-huh.
Let me see. No, I don't even know if there's any money in this fund. I
Because we
don't,
ain't taxing no one. We ain't
No.
taxing no one for our resources.
no, I don't think there's anything that goes into this because the sovereign fund itself came into it passed in 2016. Martin Saul been here since I was a child.
Mm-hmm.
Listen, we taxing people. It's going in those subsidiary books of our sovereign fund, which is the back pockets of our leaders.
Mhm. Let me see. Yeah, I don't know. I'm gonna have to find out, but I'll check to see if this legislation was passed, this National Investment Funds Bill 2022. Because you know, they like to, some things that are controversial, they like to pass them very quietly. And then when it's time to use it, they'll come and tell you that it came into effect on such and such a date. That's to keep you all busy. That's what they do.
Just
They
like
have-
all the laws on the books.
Yeah, they hide things because they know Bahamians don't like to read, you see? So they- So what are some of the general duties of a real estate broker or agent? They have the duty to follow and act on their clients' instructions. And they have to do so in a timely manner and a responsible manner and in accordance with the terms of the contract between them and their client. They have to act in good faith and in the best interest of their client. They have a duty to act in a professional manner. They have a duty to account for all the monies that are paid and trusted to them for deposit in the property transaction and client monies generally. And they have a duty to disclose any conflict of interest in the execution of their duties. So that's the duties of a real estate broker or a real estate agent. Now let's turn to the contractor. We passed in 2016 the Construction Contractors Act. And that provides for the registration and licensing of construction contractors, the regulation of their conduct and practices, a disciplinary board for complaints against unscrupulous or dishonored contractors, penalties for infractions, and there's also a rating system for skills and constructing different types of homes and buildings. So when you look in that piece of legislation, contractors are required to register under certain categories. And I've listed the categories in your module. Hold on one sec for me, please. Hold on one sec. Just give me 1 second. Okay, so look at the listing. All of these persons with these skills are required to be registered under the Construction Contractors Act. And if you look in the legislation, it also speaks, like we mentioned earlier, about training. So when you register under the Construction Contractors Registry, then you also have to have the qualifications to go with those positions. And then your license has to be renewed on an annual basis. And the legislation provides for, if you are removed from the list, for restoration. You can be disciplined as a contractor for misconduct, or if there are complaints. Or the registrar of contractors can actually have you removed from the list. Now, like you say, in Freeport is actually active. I don't know how active it is in the Bahamas. What have you seen in terms of contractors and showing that they're licensed under the Contractors Act? Anybody seen anything under the contract, any contractors showing that they are registered? No one?
I know he's in Freeport. I know that they have to bring their license in if they're gonna do any work. We'll have to make sure that they are licensed by the Port Authority. Sometimes, you know, they may have government license, but nonetheless, they must be licensed.
Yes. So what happens here in Nassau? I know they're trying to clamp down on them now with the Department of Inland Revenue, but in terms of them registering, do they provide their certificate of registration?
Yes, they'd have to provide that.
Okay.
Have to be valid.
Yeah, because that's what's required under the legislation. So it says an individual who wants to be licensed as a contractor in any year must apply to be registered as a contractor in the Contractors Register. They have to satisfy the qualification for registration, and then they have to pay the requisite fees. Then they have to submit to the board a certificate of registration, and they have to produce documentary proof to the board that they are an existing client with any locally licensed bank in the common. And then they have to produce to the board their public liability insurance of a minimum of $1 million. So to me, that $1 million only refers to large projects. That cannot be for building a home. So do you require proof that they have liability insurance, public liability insurance?
No, ma'am.
Okay, yeah. I guess that's just for the large projects. So for real estate projects and development, which may impact the environment, the government passed two pieces of legislation, the EPPA and the EIAR. And if you read the newspaper, you would see the ads in the paper where they ask the public to read their assessment reports and send in any comments that you may have. So normally people who are members of BNT or any other group, environmental group, they would send their responses in. So the Environmental Planning and Protection Act was created for ensuring the ease of doing responsible business by creating a streamlined process that require individuals to obtain environmental clearances before they commence their project. Section 11 of that act requires that no work on any project can be commenced unless there is a certificate of environmental clearance. And a project is defined as any development that proposes a man-made change to the environment or any ecosystem, whether for business, sports, or residential purposes. And that includes a physical project, a plan, a program, or policy of the private sector, government, or any other entity that has not yet received final approval from the relevant agencies. So sometimes you see a persons when they come in to do a project, they tend to prefer, since this legislation, they prefer to purchase properties where a lot of this environmental work has already been done. So if they want to say, if they wanted to invest in a resort, they would invest in a resort that already has docket slippage. The piers are already there. The harbor has already been dredged for the yachts, so they don't have to go through all of this approval. That takes a lot of time. So the EPPA states that a person is liable of an offense where they commence a project without first obtaining the requisite clearance, and that person is therefore liable either to a fine up to $5,000 or 1 year imprisonment, or both, or upon conviction on information, a fine of $10,000 or 3 years imprisonment, or both. So the environmental assessment regulation that outlined the procedures and defines the requirements and purposes or purpose of the certificate of environmental clearance. Persons seeking to commence or proceed with a proposed project must comply with the regulations. And the regulations define what is a proposed project or a project as any development, project, plan, program, or policy in the feasibility stage. And that includes any demolition, abandonment, decommissioning, modification, addition, or expansion of an existing project. So if you are in a process of doing a project, you have to submit to the Department of Environmental Planning and Protection an application for preliminary review of the proposed project and an application for a certificate of environmental clearance. And that's done in triplicate. The department would review the documents and they determine whether or not an environmental impact assessment or an environmental management plan or further studies are required. So if an applicant disagrees with the department's decision, they do have the right to appeal, or they could just withdraw their application. Consideration for obtaining a certificate of environmental clearance may include whether the applicant consists of solely Bahamian proprietors and investors, or foreign investment of any amount is involved, the anticipated environmental impact, and the level of public involvement. If a project involves foreign investment, of course, you know, the Bahamas Investment Authority is involved. They have to approve the project. So once determined by the Director of Environmental Planning and Protection that an EIA or an EMP is required, then the applicant has to submit electronically and in writing their proposal. The next step will be for the application to publish, the applicant to publish in the paper and for circulation in the Bahamas, a notice detailing the EIA or the EMP. And then they submit it to the Department of Environmental Planning and Protection for review. The department will communicate the decision to the applicant within 60 days of the date of submission of the completed EIA or EMP. If the director reviews the application and they determine that the EIA or EMP is unnecessary, or that all the requirements for a certificate are satisfied, then they will grant the certificate of environmental clearance. And that'll set out the terms and condition that the applicant has to comply with. So the general duties of a contractor is similar to a real estate agent or broker. They have a duty to follow and act on their client's instructions, and also to act in terms of the obligations and duties within the contract itself. They have a duty to act in good faith. They have a duty to build or construct the building in a safe, secure, and professional manner, taking into considerations all the relevant health, safety, construction, structural, and other risks. They have a duty to account for all monies paid to and entrusted to them for the construction of the dwelling or the building, and to use the monies for the purposes for which they were advanced. They have a duty to disclose any conflicts of interest in the execution of their duties. And they also have a duty to exercise good workmanship in the construction of the building, standard required by law, regulation, or building code established in the Bahamas. So just based on these duties, these are things you can actually put in the contract, so that when there is a breach, you'll be able to say, but you agreed that you were going to adhere to the building code and that you were going to build this in accordance with whatever regulations or stipulations that you require. But you have to make sure that your contract covers what you're looking for and your expectations. Any comments? Yes, no?
No, ma'am.
I was just trying to figure out what could be a conflict of interest for the contractor.
Well, the contractor could be the mortgagor's boyfriend. It's not a conflict of interest.
Ms. Archie, I was gonna give you a
That is true.
scenario. Sorry,
Yes, it is.
Yeah,
ahead.
I didn't think there would be that bold.
listen, because right
They
now,
do. They do.
right now, there's a case where there was the bank manager whose cousin was the lawyer, the contractor was the husband, the lawyer's husband. And so the other party was the son. So
That already sound mixed up.
exactly, there's a whole ring, and I mean thousands of dollars. Because the son had projects, right? Where the lawyer and the husband, the lawyer and the husband was the contractor, and the lawyer was the one who did all the documents. And the bank manager was the one approving the loans. So there is all kind of conflict of interest in that
Oh, wow.
regard.
Yeah.
Wow.
Yeah. Conflict of interest can happen.
I know they usually say we're not supposed to recommend any attorneys or contractors to the customer.
No, not recommend, not choose, give them a list. And they choose.
No, what I'm saying is you have some instances where you have lenders who recommend family members to do the work for the
Right.
customer.
Yeah, no, that's a conflict.
Yeah.
See, and the thing it is, right, with this one, what they did was a lot of other persons were coming in and applying for the mortgage, right? And now you come to discover that the people who applied for the mortgage isn't the people who the mortgage belonged to. Mhm. So now these loans went delinquent. And now they're running down the people, and now you're getting all these juice behind the scene as to what really went down. Because the people who come in and sign the mortgage said they ain't paying because they ain't down their place. It's a whole ring.
Oh my God. But it back to the same point that talk about this and
We're closed first. Just saying that.
Marissa need to mute Marissa.
yeah.
What I do.
You're like, you're ironing all your clothes.
Yeah. In public. Yeah, it's I don't know. I don't know. Let me see. I'm about to send you all a case called Avant-Garde. Hold on. Documents. Let me go here. And it's for today's date.
Ms. Archer, while you do that, the case that you sent us today on the assessment, is
Mhm.
normally that long? That was 163 pages? The assessments normally that long?
Yeah, they are. They are. Sometimes they're 50, 60 pages long. I just wanted you to see it.
Right.
And if, let's say if it's an area that is of concern to you, I would say as a Bahamian citizen, you should read it.
Right. I see that's the Exuma.
Yes. You should really read it. Okay. You should have gotten the case of Avant-Garde Investment Holdings Limited and Clive Guy.
Got it.
Okay. So in this case, Avant-Garde alleged that Mr. Guy breached the agreement for sale because he refused to pay the $40,000, the balance remaining on the purchase price, which was a part of the agreement. And Clive Guy was entitled to hold until Avant-Garde's completion of the construction. So Avant-Garde maintained that they completed all the items set out in the supplemental agreement for sale. And they say, so they are entitled to the $40,000. Clive Guy, on the other hand, alleged that Avant-Garde never completed the items set out in the supplemental agreement, which were the conditions of the payment of the $40,000. Now, I can tell you in the end that Mr. Guy lost. So further, Avant-Garde objected to Clive's withholding an additional $10,000 from the purchase price to account for the fact that there was no longer going to be a pool. See, what happened is Mr. Guy just kept changing his mind, and that happens sometimes. So Avant-Garde alleged that the price had already been reduced by $10,000 to account for that loss. Mr. Guy, however, alleged that the purchase price had been reduced by $10,000 for other reasons, and as a result, he was entitled to withhold an additional $10,000. The court held finding in favor of Avant-Garde that Clive is to pay Avant-Garde the sum of $40,000, which he or his counsel had retained to the present date. The Clive is also to pay to Avant-Garde the additional sum of the $10,000 as the absence of the external amenities was already accounted for in the reduction of the purchase price from $250,000 to $240,000. And of course, he had to pay the cost. So if you read this case, you will see, go to the background of this case. Now, Clive Guy is an attorney at law. So some of the background facts are not in dispute and are gleaned from the documentation adduced and used at trial. So Avantgarde Investment Holdings Company Limited is a company beneficially owned by the Ferguson family. They were the developers of the construction of a 3-unit condominium and the vendor in the real estate transaction between the parties in this action. The members of Avantgarde Company and the persons who were involved in the development are Errol Ferguson, Ivana Ferguson. Their father, Ivan Ferguson, was not a member of the company, but he was involved in the construction and development of the condominium. So in 2010, Clive Guy, an attorney at law, lecturer at Eugene Dupuche, he met Errol and expressed an interest in purchasing one of the units in the condominium, known as Celestial Breeze Condominium. And it was located in the Venice Bay subdivision, and it was constructed by Avantgarde. At that time, only the middle unit was available. So Clive Guy instructed his attorney, Carla Lockhart, deceased, to prepare an agreement for sale for Unit 2. An unexecuted draft of the agreement of sale was exchanged on the 14th of October 2010, and the deposit was $12,500. So subsequently, Unit 1 became available. Clive preferred that one because it was an end unit. It was, however, less advanced in its state of completion than the other two. So another agreement for sale was executed on the 15th of November 2010, which provided that the purchase price was $250,000 for Unit 2, but amended the deposit to $24,000. So the final agreement for sale, which is the governing agreement, was executed on the 14th of December 2010 for the unit. In the final agreement, the spelling of both Avantgarde's name and also that of Clive Guy was corrected, and the purchase price was reduced to $240,000. Also, the units were changed from Unit 2 to Unit 1. So the parties dispute the reasons for the reduction in the purchase price from $250,000 to $240,000. The parties had initially agreed that there was to be a pool and a gazebo in the common area. But when the construction began experiencing financial difficulties, Avantgarde determined that the pool would no longer be achievable. The hole had already been dug. Avantgarde says that Clive was advised that there would be no pool before the execution of the final agreement, and that the decrease in price from $250,000 to $240,000 reflected the final agreement was to account for the absence of the pool. Clive, on the other hand, asserts that his cap was $240,000 and that Avantgarde wanted $250,000 if there was going to be wooden tray ceilings in the unit. Clive opted for no wooden ceilings, and that accounted for the reduction by $10,000. So now you see how come you normally have these issues between the mortgagor or the purchaser and the vendor, or the purchaser and the contractor. Is when you start to make these changes in the contract without actually reflecting these changes in the contract. Because now you're going by two people with two different thoughts as to why there's a reduction. So in 2012, Clive engaged Mr. Roll, a construction manager and property valuer, to give him an appraisal on the unit. He found Mr. Roll on First Caribbean's list of approved valuers. The bank was the mortgagee of Unit 1, but it wasn't a party to the final agreement. So due to financial and other difficulties experienced by Avantgarde, the construction of the unit became stagnant. So frustrated by the delays, sought to create an incentive for Avantgarde to complete construction by proposing this supplemental agreement. And in that, he said he would withhold $40,000 unless and until Avantgarde completed the outstanding works. So in 2023, Clive again engaged Mr. Roll to inspect the unit to create a list of outstanding works. And the list became the punch list. The punch list was partly based on what was told to him by Clive. So on June 2013, the parties executed this supplemental agreement for sale. And that was to facilitate the completion and then chart the cost going forward. Because remember now, Avantgarde is having problems. So the supplemental agreement provided that Clive was to withhold the $40,000 until all the items on the punch list had been completed. Clive's attorney was to release any portion of the funds deemed necessary for Avantgarde to complete the construction. So it is not in dispute that no portion of the $40,000 was released by Clive's attorney to complete the construction. So the supplemental agreement between the parties expressly provides the purchaser's attorney shall withhold the sum of $40,000, which will be held by the purchaser's attorney as security for the vendor's completion of the punch list. The purchaser's attorney shall release to the vendor's attorney any portion of the retention that the parties had to agree as being necessary to assist the vendor in the financing of the completion of the punch list. Upon the vendor satisfactorily completing the punch list, the purchaser's attorney will release the entirety of the retention to the vendor's attorney. And upon release of the retention, the said contract shall be deemed to have been completed by the vendor. It shall be released from all of its obligations settled therein. So there was no provision in the supplemental agreement for any method of independently assessing completion, such as a certificate of occupancy, inspection, or otherwise, nor did it state that any such method was required. The punch list to be completed by Avantgarde for the release of the $40,000 was in the following terms. And so you can see on page 5, paragraph 14, this is the punch list that Clive Guy and his appraiser came up with. So by the execution of the supplemental agreement, the bank paid to Clive Guy the entire sum of $240. In October 2013, Arrell advised the defendant and Mr. Roll, and Mr. Roll of the completion of the punch list. In October 2013, December 2013, and January 2014, the plaintiff's attorney wrote to the defendant's attorney advising of the completion of the punch list and requesting the payment of the balance of the purchase price pursuant to the supplemental agreement. And the defendant's attorney didn't respond. So the defendant engaged Mr. Roll to do another report. Mr. Roll reported that some construction works were still outstanding. He identified a number of items which remain either outstanding or poorly repaired. And many of these were not identified in the punch list of the 28th of June, 2013. So you see where they're starting to go wrong, right? They have a punch list. The contractor worked on the punch list. And now he's coming up with another set of lists with things that were not on the first punch list. So here's all the things that he's listing now in the 2014 report. And it's even more items. So Arrell Ferguson gave evidence, Ivan Ferguson gave evidence, and Avanya Ferguson gave evidence. Then Clive Guy gave evidence. So Clive Guy says, his evidence in chief is contained in his witness statement filed on the 6th of November, 2017. He said he instructed Arrell to forward the draft agreement for sale to her, and he instructed Mrs. Lockhart to ensure that 2 corrections be made, namely, 1, the purchase price was incorrectly stated at $250 and the deposit reflected as $12,500. This is evidenced by the fact that the deposit requested was $24,000, which is 10% of the $240 as the agreed purchase price. This is primarily why the new contract for sale dated the 14th of December 2010 had to be done. 2, the name of the vendor was incorrectly spelled and stated as Avantgarde and did not reflect that as indicated as the registered company, so that had to be changed to reflect the correct name of the company. So he said that during initial negotiation, he is presented with a valuation done by Mr. Dean, where certain amenities were promised and which included a pool and a gazebo enclosed by a wall. He said he explained to the developers that the bank considered the contract to purchase as a turnkey one and would not lend him money for an incomplete structure. He said that the bank assigned its own inspector, Mr. Roll, at his expense to certify the completion process. He stated that he did not learn that there would be no pool until 2013, when he was informed by one of the other owners that they had been given a $10,000 credit for the absence of the pool and other amenities. He said that the unit was not completed as promised by February 2011, whereby he had to rent a 2-bedroom apartment, which Arrell had promised he would pay. He detailed that the construction ran out of funds and Arrell disappeared for over 5 months. He asserted that there was never any discussion with himself and Mr. Roll, and there would not be a pool or the other amenities on the premises. He said he was finally permitted to enter an incomplete unit in December 2012, and that Mr. Roll did a valuation and a list of the outstanding work. He was assured by Vanya and Ivan that they will complete all incomplete work on that basis. And so he signed the agreement to retain certain funds. On one of the visits by Ivan to the premises in 2013, he inquired about the status of the pool, as there was simply an extremely large hole in the backyard. He was surprised to learn that there was not going to be a pool. So he said, then he commissioned Mr. Roll to review the appraisal report and inspect the status of all outstanding items and to produce a construction inspection report of the unit. In this report, Mr. Roll remarked that the condominium complex was approximately 80% complete based on the construction performance to date. Completion is expected within the next 10 days. Mr. Roll stated that 93% of the unit was complete at the time of trial. So the defendant deposed that to date, he had only been supplied with a copy of the temporary occupancy certificate. And he admitted that he took the sum of $6,000 for appliances since Arrell told him to do so. So he says that the plaintiff has not completed the outstanding work, and he disagreed with Avantgarde that the punch list was completed. So let's see what the judge had to say. Alvin Roll, and then this is the analysis. Let me go down because I'm not looking at my copy. So whether the defendant is justified in withholding the $40,000 pursuant to the supplement agreement, can the defendant withhold from the plaintiff $40,000 of the purchase price? And the judge says, in my judgment, it seems unreasonable for Clive Guy to have retained the sum of $40,000 when, as an actual finding, the punch list was completed. Because remember, when he sent the appraiser came out with another list, and those items were not on the punch list. So whether the defendant was entitled to withhold another $10,000 to account for the pool and other external amenities, the judge said, what is more important is that both parties were bound by the terms of the supplemental agreement, which appended the punch list in the third schedule. The punch list states pool to be filled in, not pool was to be constructed or completed. This gives evidence to Avantgarde's position that by the date of the supplemental agreement, Clive knew that there would be no pool. It is therefore more probable than not that the reduction in the purchase price had to do with the absence of the pool and the other external amenities and not the wooden tray ceiling. There is also evidence that the other neighbors got back $10,000 for the absence of the pool and external amenities. The judge concluded that in my judgment, the plaintiff did complete the items on the punch list as at October 2013. At that time, Clive ought to have released the sum of $40,000, which his attorney holds. As I stated, I have no doubt that there was still some minor outstanding issues to be fixed, which were not on the punch list, but which surfaced in the 2014 report. Had Clive provided this court with the requisite receipts, I might have been in a position to award some damages to him. Further, in my judgment, the reduction in the purchase price from $250 to $240 accounted for the loss of the pool and the external amenities. Therefore, Clive was not entitled to withhold an additional $10,000. Clive must pay Avantgarde the sum of $50,000 not later than the 21st of June, 2021. And because Avantgarde was successful, Clive has to pay the bill. The plaintiff has provided a bill of cost in the amount of $57,900, and Clive Guy had to pay that sum. Now you see how things can go wrong, right?
Yes, ma'am.
So after all of that, he still had to pay. Because remember what I said at the very beginning of this unit. Everything is based on the contract. And when he drafted that supplemental agreement, and then he had the property appraised, and he came with his punch list, and he said, once these things on the punch list is completed, that's it, then he was obligated to pay. Now I have another case here. It's Roger Dean, and he is suing or bringing his matter against the Minister of Works and Utilities under town planning and the Attorney General's office. I'll send it to you when I finish. It's not that long. So in this case, Roger Dean, he's the plaintiff. He's the owner of a subdivision known as Melvaric Court. I've never heard of it. In the Eastern District Island of New Providence. You ever heard about it? MELVARIC. Melvaric Court. He applied for approval to use a road called Innisfree Road, which he deemed to be a public road because without this approval, he will be effectively prevented from accessing his lots. So he alleged that the Town Planning Committee has continuously refused to grant access to the said road, which he believes to be a public road in accordance with Section 53(3) of the Town Planning and Subdivision Act of 2010. So he brought this action before the court, and he's seeking relief under this Section 53(3) and 77(3) of the Town Planning and Subdivision Act. So he is asking the court for a declaration that Section 53(3) of the Town Planning and Subdivision Act applies to Innisfree Road in the Innisfree subdivision, New Providence, since the said subdivision is not a gated subdivision. He asking for an order that Innis Road is deemed to be a public road for the use by the general public. Then he wants an order that the Town Planning Committee is obliged to consider the application that he brought for the use of the Innis Road in Innis subdivision. And then he said any other relief that the court deems just. Now, the Department of Town Planning, they responded to this. And they responded to this in their affidavit. And in it, they said that Innis Road forms part of the Innis Estate subdivision, which was developed by Mr. Pandelius Stelanicus sometime around 1996, and it was later approved in 1998 under the then Private Roads and Subdivision Act, which was repealed by the current Town Planning and Subdivision Act. He noted that the plaintiff owned another tract of land which adjoins the Innisfree Estate subdivision, and that he was given final subdivision approval by a letter dated March 2011, which was exhibited along with the final approved plan. So Charles Zonical from the Department of Planning, he set up the provisions in his affidavit that since about 2009 or earlier, Mr. Dean had sought to have access over privately owned land forming part of the now Innisfree Estate subdivision. In particular, Innisfree Road as an access point to his then proposed subdivision, Melverick Court. This was repeatedly rejected by the developer of Innisfree Estate subdivision. Mr. Dean and his then attorney, now deceased, were duly advised of the said rejection by letter of July 13th and July 20th, 2009. And a series of correspondence advising against access over privately owned land was exhibited. So a final subdivision plan for Melverick Court, taking into account and addressing any issue of access points, was eventually approved. The approved subdivision plan for Melverick Court does not require access over Innisfree Road. The plaintiff is totally untruthful in his assertions as contained in his affidavit that he is unable to and prevented from accessing his property unless by way of Innisfree Road. The final approved subdivision plan for Melverick Court provides adequate entry and access points. The final approved plan provided for a clear point of access to the subdivision via Pears Road, High Vista, which has been acquired by the government, and the proposed Dean's Way, a 30-foot road reservation within the subdivision, which provided a clear access and entry point to Melverick Court. Access via the privately owned subdivision or Innisfree Road is not required based on the approved subdivision plan. The plaintiff is obliged to conform to the final approved subdivision plan. So then Zonical referred to 3 letters that were sent to Mr. Dean. The first letter advised him that permission was required from the property owners of Innisfree subdivision to gain access to that road. This was followed by a letter to Mr. Dean again from the Ministry of Environment denying approval of the subdivision, and the refusal of the developers of the Innisfree subdivision to allow him passage to have a private road to access his property. The final letter referred to the deficiencies in Mr. Dean's proposed plan, particularly the failure to include the entrance to the subdivision at Pear Drive of High Vista. Mr. Dean was then asked to revise the plan to include the access from Pear Drive. So silly Mr. Dean now, he's in court. He presented to the court the revised plan, and the revised plan shows that he has access through Pear Drive, High Vista. So the court said it is plucid and undisputed that Mr. Dean has subdivision approval for Melverick subdivision with access through Dean's Way off Pear Drive. He said it's unclear why the court would cause, compel, or force the Town Planning Committee to consider the application of Mr. Dean for the free road when Mr. Dean has an approved subdivision plan, which provides for access to his subdivision. And in any event, the ability to compel or force the consideration by the committee, the Town Planning Committee, of this request would be required to be done in another type of action. So he said the plaintiff, Mr. Dean, has access to his lots, and therefore the court declined his relief sought. So he wasted the court's time. He had an approval, but he wanted to have access through Innisfree property. And the court said, no, you've already gotten an approval. and you'll have to use the access through High Vista. So if you wish, I can send you that one also. That one is very short. Any comments?
Yes, can we get that as well, please?
Yes, you can. You can. I can send that to you.
Thank you.
And I have another one. I won't read the whole thing because it's 20-something pages, but this one was a good one. This one was a restrictive covenant. And in here, the company is called Rainbow Bay. They filed a writ of summons followed by a statement of claim, and they allege that the Farquharsons failed to comply with the covenant requiring lot owners to submit an application and gain approval from Rainbow Bay for any construction on a lot prior to doing any construction. So Rainbow Bay also alleged that the Farquharsons failed to comply with the covenant regarding the height restriction on the lots in Rainbow Bay. And they were outlined in the actual Rainbow Bay restrictions and conditions. Again, you see, we're coming back to the contract. So the Farquharsons filed a defense, and they asserted that the restrictive covenants burdening the lot were to be found in the conveyance, and that the 18 feet restriction found in the Rainbow Bay restrictions and conditions does not bind them, as they say they didn't have any notice of it at the time that they purchased the lot. They asserted that they are bona fide purchasers for value without notice, and they further stated that Rainbow Bay is not a properly constituted association pursuant to the Subdivisions Local Improvement Associations Act. And the judge ruled in favor of Rainbow Bay. So now they're before the Court of Appeals. So the appellant now appealed the decision, that's the Farquharson, on numerous grounds. The learned judge erred in law in paragraph 4 of the said ruling when she determined that the Farquharsons were bound to the Rainbow Bay restrictions and conditions, which are not the restrictive covenants as contained in the Farquharsons' deeds and or conveyances. And in her findings at paragraph 94 of her ruling, in which she determined that the Farquharsons had constructive notice of the Rainbow Bay restrictions and conditions, and was therefore not bona fide purchasers for value without notice. So the Court of Appeal dismissed the Farquharsons' appeal, and of course they had to pay costs to Rainbow Bay. The judge said, this was done before Sir Michael Barnett. The judge said a restrictive covenant forms a part of a conveyance of land at the time of purchase of the land by the purchaser. The Rainbow Bay was not a part of the Farquharsons' conveyance and could not be said to be a restrictive covenant in the land law sense. The judge agreed that the placement of the 18-foot height restriction on Rainbow Bay website did not constitute constructive notice of the restriction. The Farquharsons would only have discovered the height restriction after they purchased their lot in Rainbow Bay and could therefore qualify as bona fide purchaser for value without notice of Rainbow Bay's 18 feet height restriction, since the land purchase would have preceded the making of an application to Rainbow Bay to construct a building. There is merit in this ground. However, this point is not dispositive of the Farquharsons' appeal. Rainbow Bay was empowered to make regulations, and those regulations would have had the effect of binding the Farquharsons as members of the Rainbow Bay Property Owners Association Limited. The judge arrived at the right decision when she concluded that the Farquharsons breached the covenant that required them to seek the Rainbow Bay's approval as the approving authority before commencing the bill. Had they made such an application, they would have been made aware of the 18 feet height restriction by which they were bound under Rainbow Bay Property Owners Association Limited Memorandum of Association. So you see, in their actual agreement, they had instructions to follow. And they thought they could get around that by saying that they were not aware of it. But in their actual contract, it said that is a step that they had to follow before they began construction. So if they had followed that step, then they would have been aware. So they couldn't use that excuse that they were bona fide a purchaser for value without notice, because their contract required them to get approval from the association before they began construction. So that's another one that was on contract. I know y'all don't want to read all of these. You want me to send that one off?
Yeah, you can read them at spare time.
Oh, wonderful. So you would have read in the papers sometime back during COVID, where the Privy Council made a decision about subdivision approvals. It was in the newspaper. Malik Momin versus February Point Resort Estates, where they said the Planning and Subdivision Act had to be amended. I don't know if they've done it yet. But in this case that went to the Privy Council, it was a question of statutory interpretation, and it concerned the aspect of the planning laws in the Bahamas, in particular the subdivisions. So it says in general, subdivisions are areas of land that are being divided into lots for the purposes of development and sale. By statute, approval is required from the relevant planning authorities for such subdivisions. The question that arises on the facts of this case that went before the Privy Council is, if the necessary planning approval for a subdivision has not been obtained, what effect does that have on an agreement to sell a lot in that subdivision? So that was the question that went to the Privy Council. If the necessary planning approval for a subdivision has not been obtained, what effect does that have on the agreement for sale? And so the Privy Council went through Section 62 of the Planning and Subdivision Act, and they said that that section is quite straightforward. It says any conveyance made after the act comes into effect regarding lots not granted prior subdivision approval shall be null and void. Should I read it again? Any conveyance made after the act comes into effect regarding lots not granted prior subdivision approval shall be null and void. So notwithstanding subsection 1, where the beneficial owner of a lot in the subdivision prior to the commencement of this act conveyed or agreed to convey land within the subdivision, but failed to obtain the approval of the Town Planning Committee in accordance with Section 8 of the Private Roads and Subdivision Act, or the approval of the minister in accordance with Section 4 of the Private Roads and Subdivision Act and Section 4 of the Private Roads and Subdivision Outer Islands Act, such agreement to convey or conveyance shall not be null and void due to the failure to obtain the approval under subparagraph A and B. And any person who obtained title to a lot within the subdivision shall not be prejudiced by the failure of the owner of the subdivision to obtain the necessary approval. So in this case, Malik, he is the plaintiff and the respondent. He is a U.S. citizen. February Point Resort Estate is the defendant, and they're the ones that are appealing. That is the Bahamian company. So in 2008, February Point entered into an agreement with Malik for the sale of a lot in the subdivision for $895,000. The lot is number 36, Elizabeth Harbor Estates on the island of Exuma. The price was payable by Malik in installments as follows: an initial deposit of $350,000 on the signing of the agreement, a subsequent payment of $125,000 in August 2008, a further payment of $120,000 by the 1st of February 2009, and then the balance of the purchase price of $300,000 was to be paid in equal consecutive monthly installments from the 1st of March 2008, carrying simple interest at 7%. So the full price had been paid as of February 2013. A dispute then arose between the two parties, Malik and February Point. Malik argued that he was entitled to the return of the money he had paid because February Point, the vendor, had not obtained the subdivision approval required by the 2010 Act. And by reason of Section 62, subsection 1, there could be no valid conveyance to him. February Point argued that it was able and willing to convey the property to Malik, and that applying Section 62, subsection 2, that conveyance would not be null and void, even though there had been a failure to obtain the necessary approval for the subdivision. Malik was therefore not entitled to the return of the purchase price. So what the Privy Council did was it went through the purpose of the Town Planning Act. It then went through the interpretation of the Town Planning Act. And then it went to the 2010 acts that were mentioned in subsection 2, A and B. And the Privy Council said that the 2010 Act repealed the Private Roads and Subdivision Act and the Private Roads and Subdivision Out Island Act. But it remains useful to set out two provisions, Section 5 and 9(2) of those two legislation. So in those repeal legislation, Section 5 says no owner shall sell, agree to sell, convey, agree to convey, demise, or agree to demise any land in a new subdivision unless they have the approval of the minister. The penalty says any person contravening the provisions of Section 5 shall be guilty of an offense against this act and shall be liable on summary conviction to a fine not exceeding $4,000. And in the case of a continuing offense, to a further fine not exceeding $40 for each day. Privy Council then said, it is helpful to clarify that the date of the Town Planning and Subdivision Act 2010 came into force in the Bahamas was the 15th of January, 2011. But on certain islands, including Exuma, it didn't come into effect until the 1st of December, 2011. So therefore, those are the relevant dates for the purposes of the references in Section 621 of the Act, after the Act comes into effect, and in Section 6, subsection 2, the prior to the commencement of the Act. So in here, the judge went through Section 6.2. This first, they discussed the decision of the lower court, the Supreme Court, and then they decided to then discuss the pre-act and then the post-act. And the court came to the decision at the end that Fabry Point Resort Estates, they need to obtain the subdivision approval, and Fabry Point Resort Estates had to pay Malik the purchase price he paid plus interest. Because he didn't have approval for the subdivision. So I could send you that one. Malik Momin versus Fabry Point Resort. So that's another thing when someone comes with they're moving into a subdivision, is whether that subdivision has approval.
So, Ms. Archer, just a question, right? Let's say you already own a piece of lot in a subdivision that doesn't have subdivision approval, right? You own 2 or 3 pieces of lot in there already, and you have the opportunity to now purchase another piece of lot in that subdivision. Do you think the act itself would play a part in there, considering you already know that, okay, the subdivision approval doesn't exist and you already hold ownership to several of the lots? You think the court would rule otherwise, considering that? Would they consider that? Because like,
Yeah,
you know what you're buying, you already own some of them, you know?
So then you're willing to lose your funds then?
Oh, so I guess they wouldn't. I don't know, just thinking about it, because I know.
Because in Malik State, he had bought that property, paid it over time. But
Right.
with division approval, he can't construct.
Oh, okay. So that means, I guess it's going to affect, like, I know, in the past, a lot of times the areas that banks would have invested in that doesn't have subdivision approval. So that means for now,
Right.
a lot of them will be able to get clear title to those properties.
Right, so that's what the Privy Council was saying. The Privy Council said that we need to go back now and look at the legislation and see how the properties fall into the same category as Malik's. And they
Oh,
have to be,
wow.
I don't know if they did any amendment. I don't know if they looked at it. I don't recall seeing anything in the papers or any legislation that was passed addressing this issue.
So I guess it's just a going forward thing.
No, it's
Because
going
I
on.
know.
What is it going back to? Because if someone is on a piece of land where the subdivision was not approved and they're trying to sell it, it's gonna have the same issue. If they have a right attorney who has read these cases, then they know that, okay, stop here. How are they selling? How are we gonna transfer title when this area doesn't have subdivision approval?
No, I guess my mind was kind of on the quality business, quality something case versus the Harmony Homes case.
Uh-huh.
With the land that was sold to Frankie Wilson Does. So that's an area, I guess it's Harmony Homes is this company. So that's an area with undeveloped property. So the Lake Villanis subdivision doesn't have any, it still doesn't have infrastructure. So what happens in cases like that? Because I know, persons who own property in the back there at this point, but I guess now they won't be able to sell it. But for the persons who already hold ownership in it, I guess they just have to hold on to it for now until they get the subdivision approval.
Yes.
Oh, wow, so they can't do nothing. Kind of hands tied. But I mean, some of the big players are involved in these things. That's what I don't understand.
Yeah, but you see, the thing about it is, like I tell you, we don't read, and people don't agitate for certain things. So until it hits someone's pocket, no one is going to make noise about it. There are a lot of other cases you see come up. I think there's one under company law. It's been almost 5 or 6 years where the judge asked for an amendment to be done because there is a lacuna in the law. Something is missing when they drafted the new legislation at that time. They missed out a provision, and it may not have been intentional. It could have just been a mistake. And the judge said that needs to be put in, or some mention has to be made as to how do we address that part that was missing. It hasn't been done.
Oh, wow. And then you spoke, I mean, this may be a little off, but you spoke about having the necessary approval to construct in the Bahamas, etc. But I understand that the big new Wendy's that has been built on East Street South, that doesn't have formal approval.
How did that happen?
I don't know. How did it happen? That's what I don't understand. Sometimes you have these big players involved, and like the big players get away with it, but then you want to kind of pressure the small man.
About to say, yeah, that's what they do.
Because that drive-through was sure full today.
And
Yeah,
and
they don't have approval for that.
they're worrying about Bahamians having all these chronic illnesses, and this is what's causing it.
Exactly.
So why we put now we open an IHOP. Everybody must run for pancake from this morning. People are just be big now.
Yeah, and then with the Bahamas being one of the, I guess, top countries with all of these, diabetes and obesity and all that stuff. Like, it kind of makes me think, do we really want to improve the health of our people?
Yeah, so that's what I'm saying. Why would you give an approval for selling all these pancake waffles with heavy syrup? People be waddling all over the place. They could be fat.
I was just trying to figure out kind of how that a bake you on the main East Street, you don't have approval, but yet, you kind of functioning and nobody says nothing. And I'm sure the big guys are aware.
Yeah, running.
I'm sure they are.
So doesn't, I guess, who does like inspections, like they worry about these property taxes and all these different taxes. How about you go around and do some fining in cases like that and add that to the treasury?
Yeah, I agree, but that falls under the Ministry of Environmental Health and Planning.
Yeah, it was just a eye opener that something like that actually happened,
Yeah, but I mean, the probably things like that always happen when these are big player. Big players get done.
Yeah. But then, we kind of want to pressure the small man. And,
of course, you go out of the house and you don't have a permit, you'll see.
Yeah. You'll hear from
That's
them.
the culture.
Yes, we're back to where we started from at the beginning of class and many classes. It is a culture. And if you watch the international news, you'll see South Africa, I think on Saturday or Friday, they're up in arms over the same thing. So every leader come. All we have is corruption. We're tired of it.
Yeah, I think it's a bit much, you understand? Yeah. And then it causes an honest citizen to kind of think, is it worthwhile? You understand? But
yeah.
Big players, the power, that's just the power they have, I guess.
Yeah. Because they're the movers and shakers. You have the ministers. That's one thing who are elected, but then you have the people with the money. They're the ones that make the decision in the country. As they call them, the movers and the shakers. When they want something done, it will be done. And that's just how business works around here and in a lot of countries. So until y'all could find some honest people. And the thing about it is you could find some honest people, but I can tell you when some people are exposed to power, they change. So all of that you have to look at. All right, I'm trying to find your cases now so I can send these so y'all could have some nice reading over the holidays. Okay, I'm gonna send you for Rainbow Bay and the Farquharsons. I'll send you the Supreme Court and the Court of Appeals. With the restrictive covenant, because his head could not have been good. You're asking for an approval. I don't know why he wanted to go across these people's yard. But he did. All right, and I have the Court of Appeal right here.
Ms. Archer, you didn't give us any feedback on the supplemental exam.
I didn't? Did you get
No,
your grade?
ma'am. No, ma'am. Shut up.
Oh, hold on, I could go here. Hold on, let me do the thing first. Case.
Ms. Archer, you said the name of the case was Rainbow Bay versus.
Everybody press it over here. Rainbow Property Owners Association Limited versus Warren and Gail Farquharson.
Thank you.
I can send it to you.
I think you kind of have my box full right now with cases.
Well, y'all
versus
wanted
Gail Farquharson.
Yeah.
No, I don't have a problem with it, but I just want to make sure.
Who's yawning? No one should be yawning. That one. And then I'll send you all Roger. Let me see if I could find him. He went to the Supreme Court. Base people dying. Supreme Court. I may have to send these one because it may be too big.
You said this one is Supreme Court versus Roger?
Yeah, Rogers at the Supreme Court and the Minister of Works and Utilities. See if I can find Roger Dean. Oh, I just hate when you go to the Supreme Court. You have to dig through the Supreme Court. See if I can find it. Condominium, no. Who did this one? Gomez. No. Oh, can't find it. This is be like a needle in a haystack. That's when I find it. That's why I normally print it. Because they're hard. Good Chief Justice Winder, he said, get on with the naturalized, the foreigners. We need to deal with it. 158. Okay, did you find it? Oh man, I can't find this. I'll come back to that one. Okay, now someone was saying something. Was that you, Yvette?
Yes, ma'am.
Okay.
Yes, for the supplemental exam.
Mm-hmm. If I send those grades in. If not, I have to send you an email. To what I looking now to see. Let me see. No, that's you.
Mine as well, till this Michelle, Miss Archer.
Yeah, I have to look. Maybe in my next thing on my thing. Okay.
It's a smart class. So when I got that Wednesday, it was only me one.
I'll go. Okay, so that's Yvette and Michelle, right?
Yes.
Okay, hold on, let me see. Yeah, okay, let me just double check. I'll check my stuff and then send you all an email. I'll send it
Okay,
first.
thank you.
Okay, so let me see. You want me to let Mr. Pratt send these?
These
Yeah.
cases. Miss
Yeah,
Archer, what did the cases for? My internet went down.
Oh, no, I haven't sent it yet.
No, I'm saying, did you say what they're for? Just for easy reading?
Yes, for easy reading.
Okay.
Yeah, they're not on, they will not be on the exam unless you wish for me to put it there. Yes?
No, just as long as you list the cases that will be on the exam, I appreciate that.
Okay. Oh, I will tell you all, because I could do a subdivision one, but I'll tell you which one.
Okay.
Yeah, so you don't have to worry about that. Remember, I
Okay.
tell you about the cases because I'll give you the cases.
Okay.
When we get that list, Miss Archer?
Oh,
Now would be great.
down.
Click on the.
Well, we have a long
need to
holiday
start
weekend
studying.
coming up. So, studying could be done.
Okay, let me see if I can narrow down my cases that I will use. I'll just send you the cases.
Thank you.
Okay, great.
So you're sending us a list of the cases, Ms. Archer?
Yes.
All right, thank you.
Okay, I can send 2 here. Let me send this to Miguel so he can send you all. Any other requests now? You sure that's it?
No, I just wanted to know, did we decide on the proportions relative to the different sections as yet?
No, we didn't.
Okay.
Okay, well, everybody's on, so start talking.
Yes, I thought we said 50-50.
We did?
I don't
We
know
did?
that everybody was talking about it.
No, I don't think we say 50-50.
What?
I feel like someone
What?
suggested that. I don't know that the majority agreed
Yeah.
or took a vote.
I don't think we
I
voted.
thought
I think we
we
talked
think
about it.
60-40.
The multiple choice, I
That's
think,
what I
leave a
remember,
budget
Miss
tomorrow.
Archer saying.
I thought we did 60-40. Didn't we do that already?
No, we did that past exam. That didn't work well.
No, it was 70-30 the last time, eh?
Oh, that
Last time it was 70-30.
The
We all over the
70-30
place.
was
That
multiple
was the
choice
old
with
exam,
30
yeah, and
short
30 with
answers.
the quiz. Yeah.
I won't flip that this time. Them short answers did me better than them.
Agreed.
I
Is Stacy
want
saying that?
that's the child, so you know.
Yeah.
I have to give it to you, Dames. The short answers really, I think was better, especially once you have it, you're familiar with the cases. You can,
Okay.
put something together. Mhm.
That's what I'm saying. You could argue for, I mean, you could talk for some points. I am not a multiple choice taker. I'm just not one of those.
All right.
Don't feel bad. I'm a good multiple choice taker, and that section didn't do me all that great either. Don't feel bad.
So what we're looking at this time, you're gonna flip it around, change to 70-30 to 70 short answers and 30 multiple choice, or what?
No. Can we take a vote? I'd rather go
Sure.
50-50 than to go flip that.
All right, so we have someone suggesting
mean-
70-30, heavier on the short answer, and we have one suggestion for 50-50. Do we have a third suggestion to vote on, or we want to go with those two
Two
percentages?
suggestions for 50-50, please.
So can we
Put it
put
in
it
the
quickly
chat.
in the
Put it
chat?
in the chat.
Yeah. Okay.
Well, this is serious business.
Yeah, this is
60-40.
Okay, I heard a suggestion for 60-40, so we'll add that as a third option. So we have three
60
options to
multiple
choose from.
choice. Is that 60 multiple choice?
Yes.
Y'all
Okay.
funny now.
Oh, whoa.
Yeah,
Okay.
come on, Rita.
Oh, this is getting better.
So actually, that don't mean you must find the 30 hardest multiple choice questions or most
Of course,
confusing
that's what
ones
that
that you
means.
want, please.
Of course, that's what it means.
Of course, that's what that means.
Don't forget
That
now.
You will not pass
Don't
multiple choice section.
I have to add on some points for your presentations. I'll add them onto your midterm. But whatever grade you get on the final, that's it. Just be mindful. Okay, keep
Okay,
talking.
so all the 60-40s that we're seeing, that's suggestions with 60 multiple and 40 short answers. That's what that means? Because some people
That's
just
what-
have 60-40, but they didn't say what the.
Okay, so I'm seeing, yeah, that's what it seems like.
What, the 60-40?
Yeah, it seems like they're going, well, it seems like the 60-40 persons are proposing 60 multiple choice, 60% multiple choice, 40% short answers.
Okay.
Yeah. Mm.
So that's the conclusion? Or they just voting?
Unfortunately, that seems to be the majority vote right now.
Miss Archer, did you vote?
Who, me? No, I don't need to vote. But I'm not on. Just don't die the exam. Everybody voted?
Look like 60-40 done win.
Wait, 60-40, look at it, has 4 persons.
That's
And
all?
70-30 has 3.
I don't see a vote from Katori yet. I don't know if I missed it.
There's more than that on.
I
Thank
know.
I'll
you.
go with the majority.
Francine voted.
And so that's only 7.
1, 2, 3, 4, 5, 6. Well, you have 6 people saying 60-40.
We get a 6 from you saying the repeat.
Yeah, you see him
Nobody
repeat.
done answer 3 times.
Sylvia, what the
I just saying,
Sylvia?
Sylvia got 3 answers up there.
Yes, Sylvia.
I think she's like,
No, that wasn't the intentions. You guys were asking other questions, so I was answering the other question.
I
Like when you
realized
asked
I know, but
me-
that counted as
Yeah.
1-1.
Yeah.
That in the ballot
Another
box, I mean, in the ballot room.
She was
And
clarifying
guess what?
what her
Listen,
60
any way
40
will
was.
work for me. It doesn't matter. So my preference is 60-40, but however you do it, it works. It doesn't matter,
Pam,
honestly.
pam, pam, pam.
Okay,
Take
so
that.
we have 1, 2, 3, 4. It's Miss Johnson. And Katora, although she DM'd me, she also voted 60-40. That's 5. Fountain, Cassandra,
3,
Miss Miller,
4,
Miss Johnson,
5.
and Katora. That's 5 for
I see
60-40
5.
so far. Only 1 50-50, 2 70-30s.
Yes, Mr. Fountain.
He
Fountain,
voted
where you
already.
at?
He voted.
I thought it was 3 70-30s, no?
3, who's the third? I only see 2.
Oh, that's, okay, I see your Fountain. I see you.
You
That's
see
8
from
people. How much people we have on?
plenty.
How much?
12, 11.
Krista, it's 3, you, James, and myself for the 70-30.
Right. Ah, okay. So that's 9.
Drum roll.
9. That the 60-40 is gonna win it.
Drum roll.
60-40.
Yeah, the 60-40 one.
So that's
That's
60.
3 plus 5 is 8.
What is 3 plus 5?
Me, you and Tingham and then 40, 60 get 5.
Yeah, you're right.
But there's a
Yeah.
50-50.
Oh, yeah, and 1 and 50-50 get 1, so that's 9.
Right? That's what I
With
counted. I
other,
counted 9.
3 people.
No, it's not that much participants. You can't count Miss Archer.
Miss Arch only 1, it's 11.
And I see Veronique. I
Two
see
more, you
Veronique's
missing
name
2.
twice, which means she is on 2 different devices.
Oh.
Okay, so only 1.
Right.
Alrighty.
It's still 60-40 with James. You're doing everything to get this
I
sway in your
hate
power.
multiple
You're
choice.
70-30.
But anyways,
The thing, Miss James, their memory short and had a multiple choice beat us up on the last exam. But anyway,
how quickly we forget, leave them.
right.
What does the vote say? Let's go by the votes.
The votes say
That's
the votes say
what the
60.
vote say. You got
Listen,
short
that's how we-
memory.
That's how we do it
60-40.
in this. That's how we do it in this country. It don't matter what's good for us. Let's go by the majority vote. 60-40.
All right. Woo.
It's a democratic country. We going with it.
The rest of us just along for the ride.
God. So 60 multiple choice and 40 scenarios.
Yes, ma'am.
Yes.
All
I
right.
figure 70 was the passing mark. At least if we get 70 short answers for straight. But anywho,
I'm with you, but let's go with the majority.
now, Ms. Archer, you said that whatever we got on our midterm plus what we get on the final, you add the
Yeah.
2 together, right?
And
Yeah.
average it.
But I thought y'all were fighting to see who's gonna be the top. Get that prize.
Right.
Is it right?
There's a prize.
I just trying to make it.
It's just a certificate, most of the student in the course.
Oh, okay.
We're gonna
Interesting.
What's the prize, Miss Archer?
no prize.
A certificate.
Oh. I thought
And
It
bragging
makes
rights.
you feel good.
it was a brochure or something or somebody.
It makes you feel good to know that you were the top student.
So question, if you would have gotten a good grade on midterm and you don't get a good grade on your final, how does that work?
Man, you gotta pass. You gotta have 70 to pass, right?
Either or combined?
Combined.
Okay.
Combined. Mm-hmm.
I already forget what my midterm grade is. Look at me having to go calculate percentages now.
Miss
See what I need to
Asha,
get.
what was the answer? Sorry, my internet must dip out a minute. What was the
Fine.
answer to Katura's question?
Combined,
Okay,
midterm and final.
so since it's 2 grades, you combine and divide by 2 to get an average. That's how you can do it?
No, there's a percentage, eh?
Okay.
50. I don't know if you get anything for attendance. I can't remember. But we'll
Okay,
put
so
it in-
Ms. Arch, I'm sorry, I'm just trying to understand. So like you had someone who got, I think like an 87 or something like that, and let's
Mhm.
say they get an 80. So how do you come up with their final grade with that 87 plus that 80?
Oh, that'll be an average of the two, but I have to see what to give if we have attendance on there. Look in the front of your book, see if anything for attendance.
I was just about to ask you where we could check.
Yeah, check the front. I don't have in the front part of my book here with me.
So if you get 50 on the midterm and 50,
You
on
fail.
the end, you
That's
have
That's
a
100, that's 100%.
Well, I'm sorry.
I like good
Please
standards.
say yes.
Miss Archer, I don't see that anybody find it in the front of their book.
No, not as yet.
I on page 8.
It'll be 50% then.
What'll be 50%? Sorry.
Add the 2 grades together, divide by 2.
Okay, all right.
Mhm.
Oh, boy.
What? You
Pardon?
guess what? Don't stress. On our next class, you can take another poll.
What we voting on again?
If you're
Sorry.
We can just add the two grades together.
You have another class?
yeah, mostly another class.
We have a class, I think it's 17.
Just the exam after that.
Can we just
One
add
more
the
class.
2 grades together without dividing them?
My Lord.
Oh, no.
You may need
Miss Archer, seriously. So it's not a breakdown of attendance or anything like that. It's just
Just
the two.
Yeah.
You gotta get a 5% somewhere in there for attendance and
You get,
participation.
no, oh, I said your presentations, I will add on to your midterm.
Oh, okay.
I have all of my papers where I ask persons to present, and when you present it, I tick it. I have it.
And how much do those for?
That's 15%, eh?
I will see when I put it together. I haven't worked it.
Miss Archer making us up on the
Some
fly.
presented some presented more than once.
Yeah, some people present one, some people presented more than 3. Yep,
Somebody won't present.
So there's
Pretty
only
people
one
won't
more
present
class.
now.
What's the exam date again, Ms. Archer?
the
Confirm
22nd.
that, please.
The 22nd.
22nd?
Mm-hmm.
Oh, I think I sent you a note. I sent you a note.
That's
I saw that.
Saturday.
I saw that.
Okay, okay, thank you.
Yeah. Why you all pan?
Okay, final, main final, Miss Archer.
I know. So between
Do or
now,
die.
oh Lord.
This was a very participative class, so y'all will do well.
Yes. I don't think anybody will fail. Everybody participated. Everybody enjoyed the cases. And you learn from each other. I don't think it's going to be that difficult. Just remember what you learned. And I think the cases.
You're cutting out. You're cutting out.
Yeah. Cutting out. Yes.
So, Ms. Archer, we lost you for a minute.
No, right here.
I think your
said
internet was
something.
cutting out.
Oh, my
Yeah.
internet. Go ahead. I'm here.
There's somebody that like when you combine the two grades, they get a 66% or like something close to 70.
Well,
Or
well,
like something
pray,
close
they,
to
they,
70.
they better pray that they were talkative in class.
Bless the Lord, oh my soul. Very good.
So what if the person was shy? Because not everybody.
Over the internet?
Well, guess what? Guess what? If you realizing now that you've been very shy, you get one more class to talk.
Oh, Lord.
Miss
Over two
Angela,
kids.
not everybody has bold, Some people like stage fright.
Get up. We can't even see you.
Cassandra, take 2K, say girl.
Oh Lord. Yeah. But I know who has attended class, because like I say, I kept a roster. So I know you've been here. I know some people are shy, some people don't like to speak up. But yeah, if you get like 67, 68, 69, of course I'm not gonna fail you. So don't worry about it.
50.
Yeah.
So,
Oh,
okay, sorry, you said you
Too
tried to
far.
send us the cases so we could learn over the holiday?
yes.
Okay.
Yeah.
So 50 is what, a D?
No, 50 is fail.
Oh, what is a D?
There's no D. There's
Ain't
no
no D.
That's no
You a
D.
pass.
Either you
Yeah.
pass or you
No
fail.
D.
75. So what is
Marissa, 50 is no certificate.
Yes.
a C?
There's no C.
But
You
they don't
either
give
get a
grades.
certificate
Either
or
you
no
pass or you
certificate.
fail.
You pass or fail.
What is the grading scale? What does
70.
grading scale look like?
70.
And that's it?
Yes.
Yeah.
70% is a pass.
So 80 could be an A then.
There's no grade.
No,
80
There's
is a
no
pass.
grade.
This is a
Right.
zero sum. This is a zero sum. It's either one or the other. You either pass or you fail. They ain't doing A minus and B plus and stuff like that. It's either it's only a pass or fail.
Wow.
Oh, what happened now?
Marissa,
So
girl,
we
you
could put
got
the
this,
two.
yeah?
So we could put the two grades together without dividing. That could be a choice.
Oh,
And you reach
Lord.
100 and something.
I don't care.
That'd be an
Oh,
A plus.
Exactly. So if you got 80 something and then you get an 80 something again, that's a 100%, right off the top. That makes sense.
Cause you got that.
Half, half. You ought to be all right. Y'all finished now? It's 60-40, but I went in with. Oh, I
Yes.
know.
Yes,
Ah.
ma'am.
Check out my cases.
Yes,
Okay.
ma'am.
So it's 60 short answer now and 40 multiple choice?
I
No.
thought it was worse.
It's the reverse.
I think they said 60 multiple
They
choice
said
and
60
40
multiple
short
choice
answer.
and 40% short answer.
Wow.
Oh, sure, man.
Oh my God.
Wait, those 60-40 better think again.
I feel like this is a repeat of what happened before the midterm.
So 50-50 then.
Me and you, Miss Davis, was like, y'all sure?
So 50-50?
I think 50-50 would have been a better.
Wait,
better-
which two persons just now said 50-50?
Miss
Marissa.
Katora.
This Katora. Okay, Katora who voted 60-40.
Yeah, man. Because how she making this sound? Y'all sure y'all want 60-40? I know. Because
So
she
you sure you
reiterated
want
that a lot.
60-40 and multiple choice versus short answers? So you better put
Correct.
60 in the short
However-
answers and 40 in the multiple. So she giving us the case.
Right. Okay. Because she sound like she will make this really hard.
No, I will not make it really hard. But it's
You
let's
know,
start.
Ms. Archer, I will not make it really hard, multiple choices.
Yeah, but the point is that, you know, if you have multiple choice and one wrong, next one wrong, next one wrong, in a short, if you've learned your cases and you've read over your units, it shouldn't be that difficult.
That's what I'm saying.
Yes, but some of those questions can
Let
get
it rip.
confusing because you can have similar topics in different units, and that can cause confusion, some level of confusion. So you're looking at 7 chapters now versus 4.
Uh-huh.
You're gonna have some of those topics overlap.
Yes.
So you may see something that you're thinking applies to one unit when it may apply to a different unit, and you're answering one way,
Mm-hmm.
but the answer is something different.
Yeah, but when I do the review, right? You already have the cases. So when I tell you the question is coming like this, then you need to go now and take your cases and see which one aligns with that.
So how many cases would you be sending us?
I don't know yet.
Okay, can I pause? Just because I know we're trying to. So just on that note, right? Someone just pointed out this is 7 chapters versus 4. This is to the whole wider community, Miss Archer.
Okay.
So
Yes,
now you
ma'am.
have 7 chapters to go and read over with a fine-tooth comb, because a multiple choice question can be any random fact out of these 7 chapters.
I'm with you, Krista.
Any random fact. What percentage is X, Y, and Z? And if that's the one paragraph your eyes happen to skim over as you was falling asleep that night reading, you miss out on that point.
You miss it.
In the Court of Mastering Mortgages.
Everybody who trying to make this a heavy multiple choice exam. I mean, if that's the majority, that's the majority. But think about the extent of, has anybody looked at the length of module 11? That in and of itself, you could get 60 multiple questions from that one chapter. I'm just putting it out there, just for contemplation. That
In
is
the
all.
Court of Mastering Mortgages. I'm sorry, I can't let you walk into that blind.
Oh God. You let me know later, you know.
No, because we won the cases this weekend. Does that affect?
I think you should write a short summary of why you want, what percentage you want on this.
This is long writing.
Yeah, but nobody could judge that. That's the thing.
Okay, so for the final, we're going from module 7, or are we going from module 5?
5.
5 to 12.
Module 5 to 11.
5 to 12, eh?
5 to 12, eh?
11.
Yeah,
eh?
5 to 12.
Oh, it's
5
11?
to 12.
Sorry.
No,
12.
module 12.
11, 12, I think. Or there's no 12. I don't have.
Yeah, there's a 12.
There's a 12. So,
Okay.
so just stick a pin in that. That's actually 8 modules, not 7.
Very good.
This is powerful.
Once again, just pointing that out.
and one to 4, beat you with a stick. Okay.
Right.
Okay.
So this sounds like we need another midterm before the final.
Don't do it. Don't do it. Don't you dare do it.
I think the long holiday weekend is a good opportunity to present another midterm.
Another one.
Contemplate the meaning of life.
on 4 of the
You know, Mr.
chapters that
Achake
are
already
given
gave us
in
an
the final,
opportunity to do a
with the
supplemental
final, on
exam.
the final 4 chapters.
So y'all didn't take advantage of the supplemental exam? Y'all asking for another exam?
Yeah, I did send a supplemental one to the office, right?
Some of us,
Yes. and
some of us
some
didn't
of them
do
took it.
100%, but we did too well for the supplemental. Not that I'm worried.
So y'all sitting good for the final?
Miss Archie, you got my supplemental.
I have to look and see. I have quite a bit of envelopes here. I have quite a bit. From some other classes too, the people did supplementals.
Well, we know our grade going into the final.
Yes, if you want to. I mean, why stress over it though?
That is true too.
Just focus on the final exam. Don't stress yourself. Try to get the highest grade you could get on your finals.
Ms. Archer, with that being said, in the court of mastering mortgages, the judgment is for the plaintiff. Krista, we'll take the 1730.
70 multiple.
Not 70 multiple choice.
No, don't let's miss
Oh.
it.
Around there.
No, we're trying to argue for less heavy on the multiple choice.
Okay. Let me take 60-40. What the class wants.
Everybody who voted 60-40, y'all still on the 60-40?
The multiple, heavy on the multiple or less?
No, we can't go no heavier. No heavier.
No, I
we
said
can't
have
put it
the 60 heavy on the multiple or on
So
the short?
the vote was 60% multiple choice, 40% short answer.
Right,
Question
so
to
I'm
the group.
asking if the flip
Does any-
side,
Oh, you're asking them to flip it?
yes.
Ooh, that might be a hard sell, Miss Names. I ain't gonna lie to you. I'm with you, but that might be a hard sell. Anybody interested in amending their vote?
They're gone very quiet.
I see that. Okay.
Whatever y'all decide, I'll go with.
I'm all
That's
for the
not how
short
voting
answers.
works.
Heavy on the short answers.
Would you say, Marissa?
I'm all for the short answers.
Did you vote earlier?
I did.
She did. She actually voted 50-50, which is, I was cool with that.
So
Yeah.
she's willing to come to the 70-30 side. Is that what I'm hearing?
Yes, ma'am. You could give me
Okay, and then
100%
so then
short
if we add her, and then Yvette says whatever we decide, sound like we may have the majority.
Yeah, I
Daddy,
heard a
Daddy
swing,
said
that's
nothing?
right. I did hear a swing vote.
Oh,
That's
Lord,
the
but-
swing vote.
Ms. Archer, I thought we already reached a decision. I don't understand why
Yeah.
we're still on the same thing.
So are we agreed? 70 scenario, 30 multiple choice?
No, we didn't agree to that. The
No,
initial
ma'am,
agreement
we
was
didn't agree to that.
60-40.
60
Alright,
So
multiple.
the initial agreement was 60-40, so even if they prepared to go 50-50, but that other one, I don't, you don't have my vote.
Okay, so for those who wanted to do 70-30 then, could we do a 60-40 the other way? So 60 short answer, 40 multiple choice.
No.
Okay.
Yeah. Yes, uh-huh.
I need you
Yay.
guys to please excuse me. I have to
Sylvia?
step out. I have to step out. Whatever decision is made, I am fine with.
Okay, all right.
All right.
Okay, so what is it?
My 70-30 people, y'all say 60-40 with 60 being short answer. We okay with
Oh.
that?
Yes,
No,
ma'am.
60 will be multiple choice.
I hear no.
60 multiple choice.
Oh, she's asking a question. If we dumb
Oh
it
my
down to
God.
60-40, we take the 60 to be the short answers.
Miss
No.
Marissa, give me your
No, the
vote, please.
60,
Yeah,
60
I-
multiple
I'm willing
choice.
to do 60-40, that's fine with me. 60 short
Okay,
answers.
All
All
right, Miss
right,
Mercer,
Krista,
60 short
scratch it
answers.
and let's do it again.
All right.
We starting again?
Okay, here we
Yeah,
go.
because some people still, so 60 short
Could you
answer,
hear, could you hear me?
60 short.
I think
Option
Veronique
B.
is asking, Veronique, sorry, is asking if a question.
Oh,
She's
okay.
asking if we can hear her.
Okay, okay.
Option A.
Oh, so we're saying A or B, A?
Yes, to make this easier.
On the chat.
So we're
Option-
voting again?
Yes.
Okay.
Oh, whoa, whoa, whoa. Hold on. We're doing option A or option B?
You put in B, Krista?
I put in B right now. It's there.
Okay,
Option A, 60 short answers.
all right, hands go. I see A. A. I see.
Yeah, Cassandra is B without saying it because she'd already put 60 multiple. 1, 2, 3, 4,
Well,
5,
that's
6.
A, because
Right.
Zenobia gone. Zenobia originally voted for A, so we still back to A.
Okay, so 60 short answer, 40 multiple choice.
1, 2, 3, 4, 5, 6, 7.
So no, we say
Zenobia.
whatever the majority decide.
Yeah, so 7 for A.
All right, so Miss Archer, you see what we want?
Yes, 60 scenario, 40 multiple choice.
Yes.
Okay. All right, done. Nobody wanted B. I'll change your mind quick.
No, I thought I voted for 60 multiple choice. 40
Yvette
short. I think
Johnson.
y'all
Yvette
switches around on
Johnson.
me. Y'all switches around on me.
Okay, give a B, we still win.
Even if it's B, Miss J, we A still have the majority. We'll
Why
count
y'all
yours
switch
as a
your
B.
mind so quick. Y'all let Krista and Michelle switch y'all so quick.
They can thank us for it.
Baby.
I don't need
When they
Miss
get their
Archer going-
certificate.
I don't need Miss Archer going looking for 7 random multiple choice questions in those 8 chapters. And then we don't remember the answer. We read.
Yeah, they be too closely worded.
Let's be too close, yes. Mix your own
So
self
y'all
up.
might as well go 50-50.
So this final now.
Question.
Go ahead.
Isn't that tied 4-4?
Go to 4.
Like 4A, 4B? No?
No, what are you looking at? You looking
We
at
have
Ms.
5
Johnson's
A's.
section?
We have 5 A's.
Okay, I'm missing someone then.
I see 6s.
Well,
Okay.
Miss Johnson, she voted A by mistake, so she changed it.
Oh, okay.
So 5 A's, and even if we count Miss Miller who left as a B, that's still only 4 B's.
So that'll be in 4 A's and 4 B's.
5 A's and 4 B's.
Okay.
All right, so we good now?
Isn't democracy a beautiful thing?
So we're good.
Yeah, I get
Again, judgment for the plaintiff.
Okay. Okay. So I'll send you all the cases when I finish going through my. Which
Okay.
one? 6
I have
scenarios.
one more suggestion.
Go ahead.
Okay, seeing that, excuse the music in the background, that's what I have to do. But seeing that, they choose the 16 short answers, can you, put in a few extra short answers so that we could like choose to answer some, like choose what we want to answer?
Yes, it won't be 6 exact ones. I give you more than 6.
All right, and
So
can we
you
have a
give us
bonus?
like 8 and then do any 6 of the 8, something like
Uh,
that. I think that's what she's asking.
Yes.
Okay. Good suggestion.
Yeah.
Agreed.
Mm-hmm.
What about the bonus question as well?
Yeah. Good.
So what if you answer all 8?
No,
She
no, no,
only
no.
asked for 6.
You can't. It only needs only voice 6.
Just checking.
Okay. I put bonus there. I'll give you a question.
All right.
That'll be good now.
Yes, ma'am.
Ma'am.
All right. So that's 40 multiple choice questions and 8 scenarios, choose 6.
Yes.
Okay. All right then. I'll send you all a list of this.
Thank you, Miss
Thank you.
Archer. I think you give them too many scenarios till they think they're in a court of law now.
At least, trust me, you'll remember them forward. You will.
All right.
All right.
Good
Good
night,
evening.
everybody.
Good
So
night.
Tell me go for the exam thing. The supplemental.
Oh yeah, I already wrote it down.
All right, thank you.
Yes.
Good evening.
Or,
Thank you.
or 10 questions instead of 8.
Good evening.
I put it depends if I could come up with more, I would. Not 8.
All right, thank you.
Okay. All right.
Good night.
Good night.
Good night.
All right. Good night.
Good night, Fountain.